Thank you for joining us today. So we are going to talk today about probate. I call it the dirty P word in estate planning and administration. Folks are often very scared of this probate word. So let's get into it today. I'm super excited to have you join me. So let's get into it. During the past 2 weeks, we did a series on Probate 101. We gave you all the nitty gritty and all the facts about probate, right? And so today, just kind of like a recap to make sure that if there are any questions that they are answered, and to just generally tell you about it, okay? So let me debunk the first myth, and some folks will not agree with me. Probate is not a dirty word, okay? It's unfortunately or fortunately a process by which the court supervises the administration of someone's estate. And what do I mean by estate? I mean the things that you have when you pass away that are held or titled in your name. That's your estate, okay? Some of us have a big estate. We have lots of things. Some of us have a little estate. We don't have that many things in our names. But everyone has some sort of estate, right? The things that we value during this life that are going to be passed on one way or another to our loved ones or to the people that we deem to be our beneficiaries. So I will say that the probate process is very state specific. Probate as it exists in the District of Columbia, the process versus Maryland versus Florida, where I'm licensed, are very different. The words are different. The types of probate are different. While there's some similarities, you should really inform yourself of the process in your state and follow those guidelines, potentially with the assistance of learned counsel, okay? So one of the questions that I get asked, and I'm going to answer some of those questions, do I have to go through the probate process if I have a will? And the answer is yes, okay? If you have a will, the probate process for you is called a testate administration. Testate, that's the legal word. If you do not have a will, it's intestate, without a will, okay? If you have a will, generally, your wishes and desires for your loved ones are written and in compliance with the state, and those are going to be followed while the court supervises the probate process. If you do not have a will, the state has a statutory scheme of how they believe distribution should be made best based on who's your next of kin, and that schematic is going to be followed. So whether or not you have a will or not, you are going to go through the probate process. The only time you do not go through the probate process is if you have a trust, okay? So with or without a will, generally, you are going to go through the probate process. And if you have a trust, you may still go through the probate process, because generally when you have a trust, you have something called a pour over will. So that's the first part of probate. The second question I generally get asked is, how long is this process? At least in the states where I practice, the process, when it's not contentious, is approximately 6 to 9 months. Approximately. And the reason we say six to 9 months approximately is, for most people, they may have a house, and the house is the largest piece of estate in the largest piece of property in their estate. So it may take a little bit of time to sell the property, to marshal all of the assets, to inventory all of the dead person's assets, and then to eventually sell it, distribute it in kind or in cash, however is in the best interest of the estate and the heirs, right? Or the beneficiaries. So 6 to 9 months. If it is contentious, it can last a very long time. There are some probates that are, lasting years and years, and the court continues to supervise them, right? So it just depends. Obviously, we want you to have a will so that your intentions are clear, so that it diminishes the potential of a will contest, the potential of a contest or feud among family members and beneficiaries, because anytime that there are feud among people when somebody dies, obviously the estate is impacted negatively, and obviously the family members that are going through this very difficult time in trying to grieve are also negatively impacted. So definitely want you to have that. But 6 to 9 months is the average process. The other question that I get asked on a weekly basis is, I am an heir or a beneficiary. And when I use heir or beneficiary or legatee, those are just legal terms that mean someone is inheriting from someone who is deceased, okay? Heir is a term that's used when someone inherits without a will. Legatee is someone inheriting when there is a will. And then beneficiary can be a catch-all term or a term when someone's inheriting when there's a trust, okay? So just want to make sure that I define those terms as I'm giving you this spiel. So, you know, one of the questions that I get asked is, I am an heir to this estate, and the person who's the personal representative, the person administering the estate, is either not talking to me or they are doing something that I disagree with. And can I do something about it? And the answer is it depends. It depends on what they're doing, right? Certainly a personal representative has a fiduciary or a legal obligation to administer the estate according to what the laws are set forth in the state. They're supposed to take due care to ensure that the property is preserved, that all rights of all the people that are inheriting are preserved. But for example, let's say there's a house in a state and the personal representative decides to sell this house, and you as an heir would have not wanted this house to be sold, it doesn't necessarily mean that you have a right to stop that process. Or they don't have to ask you to sell it. Or they don't have to confer with you to sell it at a certain price. Certainly in line with their obligation, they're supposed to try to sell it at the fair market value or the best price, right? They're supposed to make sure that they are keeping everyone's best interest at heart, but they don't have to confer with everyone that's involved, every interested person, everyone that's potentially inheriting. So I hope that question's answered. Third, I think we're on fourth question. Fourth questions that I get asked often is, when I die, do my obligations go away? Do my debts go away? And the answer is not necessarily, okay? When someone passes away, we have to publish in a newspaper a notice of creditors that gives everybody who is a potential creditor the right and the obligation to file any claims. So let's say, I don't know, you are a credit card company and this person died leaving a credit card balance of $2,000. That creditor can file a claim so long as it's filed timely and they follow the statutory requirement in the state that it's filed, okay? And so this dead person, this decedent's estate, is now obligated to pay this obligation back. And this obligation has to be paid prior to any heirs or legatees receiving their distribution. So obviously, if a creditor doesn't make a claim, sometimes it happens that there are claims out there and the creditor does not make a claim. The claim may be barred. In some states, you are required to provide notice to all ascertainable creditors to ensure that all creditors have the right to make their claims. So I can't know about I'm giving the example, the $2,000 credit card statement from the client and then not send that notice to the creditor because I'm hoping he or she or they are not going to make the claim. So just because you are no longer with us doesn't mean that your obligation expire with you. Okay. And certainly there's certain obligations that we need to be more vigilant of, especially those from the taxing authority. If you think of the state taxing authority and the federal, the IRS, the taxing authority on those ends. The third question, I think I'm at number 5. I'm not a good at counting on Fridays. But the fifth question that I sometimes hear about is it probate more expensive than going through the trust administration process? And I think in our coming weeks, we're going to have a series on trust administration. And the answer to that question is it depends. Okay. I think that it's my opinion, and I'm going to stand by my opinion. I know that other lawyers may disagree with me, that depending on the family structure and or dynamic, At times, it makes sense for folks to go through probate. Some folks need a person in a black robe to tell them what is what and how it is, okay? The trust process is very much a private agreement in which administers the person's assets, right? Generally speaking, a trust is administered without the need or for court supervision or court assistance, generally. And so hear that word generally, right? But when there are certain family members that either will not listen to each other unless a person in a black robe, a judge, says, this is what you're going to get, or signs a court order in the administration process, sometimes probate is the best way and the best thing for them, depending on that family structure. So probate is not always a bad thing. It just depends on what makes sense. Also, at times, folks don't have enough assets to put in a trust, okay? If we're talking about someone that potentially has $20,000 in assets, it may not make sense to put in an entire trust, to draft an entire trust, to have an entire trust being administered for $20,000. That may not be the best use of our time. And so, depending on the circumstance, I sometimes feel that probate may be the best option depending on the family dynamic, what's happening among family members, how much in terms of assets are available for distribution upon the person's passing. And then I'm going to answer the last question, taxes. We talked about, if you were there for a tax series, we talked about taxes. Your taxes do not go away. It is absolutely imperative. If, someone passes at the end of 2022 and they worked until that time, then we, at a person's passing, as part of their estate, we have to do a last tax return for that person individually. And then we may have to file an estate tax return. At this time, I think I have about 2 minutes left. If there are any questions about probate 101 or any questions about probate, I'm happy to answer them. If you'll just put them in the chat, I'm happy to answer those for you. Otherwise, I thank you so much for joining me today. I hope that I answered your questions about the probate process. If there are any more specific questions, or if you're dealing with this very strenuous process and you're in need of assistance, we're happy to help you. Even if we're not in your state, we're happy to refer you to learned counsel in those other jurisdictions where you may seek the assistance that you need. I thank you so much for joining us today. I'll wait for about 1 more minute. And perhaps I'll answer a couple more questions. I have a list of them while I'm waiting, but I do want to thank you for your time today. Thank you so much, Spin and Tonic, for that very informative. Thank you. Thank you for showing up today. Really appreciate it. I hope that was helpful. Adrian 8271, thanks. Great job. Thank you so much for the compliments. We're happy to bring this to you. If there are any topics in the future that you would love to hear about, our goal is to have you be informed. I believe that knowledge is power, and the fact that you come out and listen to this is indicative of the fact that you're interested in the information. So feel free to drop us a link of any other topic that you'd like to hear about. I thank you, and I wish you a happy day. Take care. Have a great one.